This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we talk about an unopposed motion to dismiss is deemed confessed by every federal district court judge. And when you act as your own lawyer, failure is almost certain. No suit can be maintained if the claims made in the suit are facially implausible. In Gabaryaahla, Israel, and Akiva, Israel, Beneficiaries versus Caliber Home Loans et al., the United States District Court for the Western District of Oklahoma on July 11, 2025, dealt with motions from Wells Fargo Bank to dismiss the plaintiff's complaint for fraud, among other things. Plaintiffs who are self-represented failed to respond to the motions to dismiss within 21 days, as required by the basic court rules, and noting that any motion that is not opposed within 21 days may, in the discretion of the court, be deemed confessed. The plaintiffs brought this action against the defendants, alleging various claims such as fraud, Trover, unjust enrichment, RICO violations, and violations of consumer protection statutes, including the Truth in Lending Act and the Real Estate Settlement Procedures Act. They sought to enjoin a foreclosure action proceeding in Canadian County District Court, providing declaratory relief for fraudulent mortgage assignments and award damages. The key allegations of the complaint was securitization and assignment. Plaintiffs alleged that the loan was securitized and assigned to Midfirst Bank, releasing them from their obligations. Plaintiffs claim that the defendants received an insurance claim payout covering the value of the property but failed to disclose it. The court found that the plaintiffs' claims were facially implausible and failed to meet the pleading standards for fraud. The court also noted that the plaintiff's complaint did not comply with the requirements of Rules 8A and 9B of the court. In its motion, Midfirst argued that the court lacks subject matter jurisdiction pursuant to the Roker-Feldman doctrine that precludes lower federal courts from effectively exercising appellate jurisdiction over claims actually decided by a state court and claims inextricably intertwined with a prior state court judgment. Therefore, a complaint must contain a short and plain statement of the claim, showing that the pleader is entitled to relief. The pleading standard for fraud is, however, higher. A party alleging fraud must state with particularity the circumstances constituting the fraud. Although a pro se party's pleadings must be liberally construed, the court cannot take on the responsibility of serving as the litigant's attorney in constructing arguments and searching the record. The court found plaintiff's complaint failed to state a claim for which relief can be granted. Plaintiff's theory that the loan was paid off by a securitization is therefore facially impossible and implausible. Pro se status does not excuse the obligation of any litigant to comply with the fundamental requirements of the federal rules of civil and appellate procedure. A judgment has already been entered in a foreclosure action in the Canadian County District Court between many but not all of the same parties, and therefore the court dismissed the plaintiff's complaint in its entirety without prejudice and without leave to amend. In my opinion, it is almost guaranteed that when a plaintiff represents his or herself and fails to comply with the court rules, the pro se plaintiff will lose. In this case, the plaintiffs failed to represent their own interests, presented an inept complaint that exceeded the ability to sue in federal court, and lost their suit, wasting the time of the court and the funds of the defendants who needed to defend against this spurious suit. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and also gain access to the more than 5,100 blog postings and digests of important or interesting insurance law cases. You can also subscribe to these videos. They're free. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in additional information about insurance, insurance law, insurance fraud, and insurance cases, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.